Nancy, thanks so much. I always like the opportunity to come up and talk to the folks who are actually, you know, trying to plan for services for family members, but also the folks who are just sort of making sure that all of the services that are available are tapped into. And so coming up to meet with you, Nancy said that she learned, you know, from me when she was meeting with me on your own planning. But for me, you know, I'll have the sort of the legal perspective and helping clients navigate it, but the boots on the ground and the practical application and how it really works, that's where I learn from you know, Community Bridges and the folks who serve here, so thank you. I like that you set it up as sort of a boxing match, so I'm going to sort of talk how these are a little bit, you know, these are alternatives, and we're going to be talking about, I'm going to use sort of a scenario of someone coming up on 18. The issues that I'm going to talk about for guardianship are going to apply to anyone of any age, but you know, there's a magic line in the sand, age 18, and you're an adult, and you're endowed with and presumed to have the capacity to manage all of your affairs that I realize that I take for granted every single day on making decisions for myself. Okay. So I put together a hypothetical that I'm going to build on. So I wanted you to meet Sam. You know, it's a name that I wish I had that could have been for a boy or a girl. But Sam just turns 18 and still in school. And so at that age of 18, inherent rights are cloaked around Sam. And some activities that we do take for granted. Perfect. That we take for granted that an 18-year-old has is, you know, all of the rights of privacy in their own person and about their own personal information. You know, who are they going to be friends with, associate with? You know, are they going to be able to travel independently? Are they going to be able to choose where they're going to live? How are they going to take care of their own bodies? How are they going to manage their own health care? What doctors are they going to choose? All of the things that, you know, on the surface, you know, might seem very broad. Once you start drilling down, there's a lot of decisions that are bundled in any of those particular choices. And so, you know, some of the things that Sam might not be able to fully manage on his own are personal medical matters. And so the questions are thinking about, can Sam, at the magic age of 18, manage money from a part-time job that Sam has? And, you know, working with families, where families have been doing a lot for a child, the question about whether or not Sam's generosity of spirit, where Sam might give the shirt off his back, is going to make him vulnerable to folks around him. And, you know, families do a great job of building supports around a minor child as they're going through school, and then a child from 18 to 21 while they're still in school. And the safety net is built. And if Sam is living at home with Sam's parents, we're going to go back one, forward one. Okay. So if Sam is living at home with Sam's parents, you know, given the unique needs that Sam might have, I'm going to add to the hypothetical, he's not just turning age 18, but let's say Sam could, in fact, apply for supplemental security income. At age 18, in the household, the parents' income and resources are not going to be deemed to be Sam's. Sam's going to be an island on his own. And if he has a minimum amount of resources, $2,000 and under, he's going to be eligible for SSI if he has a disability that SSI considers worthy of needing assistance. And he previously has spent all of his money very quickly. You know, he works a part-time job, but when he gets the money in the door, rather than saving the money, he's holding on to it. And as I said, you know, we have a lot of clients who Sam's just doesn't understand the concept of money, and so when it comes in, it goes out. And it goes to friends, the generosity of spirit. He's not able to manage those types of executive functioning skills of managing money. So because Sam is 18, You know, those school officials, the parents have been involved with Sam's educational process all the way up to age 18, this arbitrary line in the sand. School officials are not going to be sharing information about Sam's education and what his needs are and whether or not an IEP is going to be implemented properly. You know, Sam is presumed to be able to manage that on his own at age 18. And the same is true for medical professionals. You know, medical professionals are not going to be sharing information with Sam's parents, the way they have with Sam all along. So I'm going to add to the hypo. So we have, one more slide?
This one?
No, back one. Back. So slide 7 on your screen. One more forward.
6. That one.
One more? Okay. So what if at age 18 Sam just he decides not to apply for SSI? It's his decision. He's 18. He's a legal adult. What if he doesn't apply for the Medicaid services to stay connected with Community Bridges? But Sam might be eligible for some or all of these public benefits that really would increase the quality of his life based on his disability. And those government agencies are just simply not going to process an application for the benefits for Sam. If a parent walks in the door without legal authority under a guardianship or as an agent under a power of attorney to process an application for cash assistance for Sam or for medical assistance from the Medicaid program. So what if Sam wants to get a driver's license? If Sam wants to get a driver's license, and all agree, including his doctors, that he shouldn't be driving, let's say, you know, who is going to be making informed decisions about Sam's ability if Sam's not able to do it himself? And there's so many different scenarios about family members who are coming in the door, but these are just sort of to highlight some of them. So when parents are faced with sort of a situation like this, you're running up to an 18-year-old, and you're worried about not being able to talk to the folks at the school about his classes, and he's going to stay in school until age 21. Or he's running up to 18 and you need to make some medical decisions for him. The first thing you have to just sort of think about is what do you want to do as a family member? Because I have some folks who have come in who would prefer to stay parents and not be the guardian of an 18-year-old. It's uncommon. It's more common when there isn't a parent and a child scenario, but perhaps a sibling scenario. So it's really important for the people who are thinking about how do we keep the safety net going, how do we make sure that this child or this individual has all of the supports he or she needs, is to figure out what that person wants to do. And second, how do you help? What can you do? And that's where the two different forks branch off on the road. So before considering guardianship, it's really a serious undertaking. It's a legal process. It's through the probate court. It could be for the duration of the individual's life. It's a public process in ways that a power of attorney is a private process. There are other ways to manage someone's money. Let's say Sam has the capacity to apply for SSI on his own, but he still needs supports on how to manage the money. Well, becoming his representative payee through the Social Security Administration is a way to help Sam and manage Sam's money without applying for guardianship over his estate through a court process. There's still accounting by a representative payee, so there's accountability to the Social Security Administration, but it's an alternative to filing for guardianship to manage a supplemental security income check of $771 a month. Holding assets in a joint bank account. So I had some clients who came in recently and their son has some atypical needs. You know, he's going to need some additional supports, but he's heading off to school. And they wanted to be able to help him manage the bank account. And they became joint owners on the bank account. So they can see whether or not the money that they put in on a monthly basis is being spent in a way that's of concern to them. It's still the individual's money, but there's another set of eyes looking at what's happening and maybe intervening and pulling back before harm occurs, which is really what the intention is when you have a guardian or an agent under a POA, is to sort of keep those safety nets in place for an individual who doesn't have the full spectrum of executive functioning skills to make decisions, informed decisions on their own. So I want to go to, you're a step ahead of me.
Following your flip.
So let's say I want to start with powers of attorney because they're a least restrictive alternative to a guardianship. And not everyone is going to be able to execute an advance directive, a power of attorney. And guardianship might be necessary. But at age 18, simply because someone needs some additional assistance doesn't automatically push them into a need to be under a court-supervised guardianship proceeding. So if Sam actually has enough capacity to understand and identify people that Sam trusts, people that he would want to name to manage financial and medical matters if he ever lost the ability to do so fully, then signing powers of attorney is that least restrictive alternative. It's that private alternative. And it gives Sam more control over the scope of the powers that he's giving to his agent, rather than having little control when a guardian is appointed and provided what the court believes the ward needs. So powers of attorney come in a couple of different flavors and styles, and I just sort of want to go through them and talk about the differences between financial powers of attorney and healthcare powers of attorney, and the different types of powers of attorney that could be put in place. So just like a guardianship, thank you for this. Right, just as a I'm using it. So just as a guardianship comes in two different styles over the person and estate, powers of attorney come in power of attorney and advance directives for financial matters, powers of attorney for healthcare and medical decisions. And I put up here educational powers of attorney because we've been using these more frequently for individuals who, have the ability to move along on a path for independence, but do need some isolated supports in certain areas. And those are limited powers of attorney. So you have financial and healthcare powers of attorney. Powers of attorney are not court-created. They're entirely private. Individuals can work with a lawyer, or the healthcare powers of attorney are available online. And if they have sufficient capacity, we're really allowing for more independence of the individual. There's limited or general powers of attorney. There's temporary or durable powers of attorney. And there's springing or immediate powers of attorney. They all fall within this advance directive, no guardianship needed category. So I just want to describe what the purpose of them are. So the purpose is for Sam, the individual. He's the principal. He's the person signing the document. Sam is authorizing an agent, his attorney in fact, to step in and handle certain matters defined in the power of attorney when Sam doesn't have the capacity to do so, or when Sam authorizes the individual to do so. So they're revocable at any time. If you have the capacity to sign a document cloaking an agent with authority to manage money matters, and you have the capacity to say, I really don't want that individual in that role, you can revoke the power of attorney. Unlike a guardianship, which is a legal relationship that's defined by a court process, this would involve, if you revoke it, signing a new power of attorney and revoking the one that came before, so Sam could name the new person that Sam wanted to have in that position.
Does that have to be seen in the court system by a judge or anything?
It does not. So as long as the individual, if Sam has the capacity, mental capacity to understand what he's signing and the choices that he's making, it doesn't have to. It's a private document. It's outside the court process. But if you revoke a power of attorney, I always tell clients, deliver it to anyone who has the old one. Because an agent is going to have the authority in front of a financial institution who has the old document. And so you just want to get the information out there and put doctors on notice that you've changed your healthcare agent, if it's a healthcare power of attorney, and banks on notice so that the agent's authority disappears at the institutional level. The agent's authority is controlled by the terms of the document. What Sam wants to cloak the agent with the power to do. It's the four corners of the document. So Sam has the control to define what his helper can and can't do. And everyone over the age of 18, although it's really hard to get 19-year-olds to think about their powers of attorney, anyone over the age of 18 really should be signing powers of attorney. And I'm going to talk about surrogacy for healthcare in a minute. But without the powers of attorney in place, if there's a true loss of capacity to manage money or to make medical decisions, long-term, guardianship is the path that people have to take, rather than a private path that someone might be able to follow. So let's talk a little bit about limited versus general powers of attorney. And I'm going to focus on the financial power of attorney first, and then talk about the medical power of attorney. But the agent's power, as I said, is limited to the document. And so it's not going to be any more or less than what Sam wants to give, let's say, a parent the ability to do for him. And when Sam is going to sign the power of attorney at age 18, and so I've just prepared one for someone who is heading off to college. And the questions of an 18-year-old are sometimes more poignant than the questions of a 42-year-old who's signing in and says, oh yeah, I want to give them all of the ability to manage all of my money because I don't know what situation is going to arise in the future. But when I was talking to my client who was 18 and heading off to school, so what does it mean? Does it mean they can sign a check for me? Does it mean they can go into the bank and look at my bank statements? Does it mean they can stop me from doing what I need to do? And so a general power of attorney is a very broad power of attorney. We deal with money matters every day. It could be signing a contract. It could be opening a credit card. It could be processing a student loan application for someone. It could be just navigating the educational system at a university or over the age of 21. And so a limited power of attorney is much more focused. It's offering just the authority to do a specific task. So when my mother was selling her property in Florida a couple of years ago, she signed a limited power of attorney so I could be the runner. I could be the one doing all the legwork, and it was focused to selling her property in Florida. It was a limited time period, and it was a limited purpose. She has a general power of attorney at 86, but that sits in a vault under safekeeping because she simply, bless it, doesn't need my help managing money right now. So a POA also can be either durable or not durable. Most powers of attorney are durable. Durable just means that it survives the principal's incapacity. And that's really what you want. You want a document that's in place to be used in the event the individual who signed it has named an agent to step in when they can't manage their own money matters. So most powers of attorney that are created are durable by nature. I've only had a couple of powers of attorney that are not durable, and they are really for those limited purposes or a limited time period. I put the example. Can we go back just one? I wonder if I put the example up there. I didn't. I shoved something in between those two paragraphs. So I was thinking about a client of ours who had, it was a bipolar disorder. And while her medication and her life circumstances were going well, she was managing everything on her own. And she didn't need to have that power of attorney out in the field. But it was an immediate power of attorney, and it said the agent could manage finances day one. And she kept it under lock and key until it was needed. But the durability of that meant that when things went awry, and she was having an episode where she couldn't manage the money, her agent was able to step in at that moment. And then, when things leveled out for her, she was able to take that document back from the agent, tuck it away in a safe place, and it's there ready to be used if it ever occurred again, which is why the durability is so important. Otherwise, without durability, you can name an agent. If you lose capacity, the agent can't do a darn thing. So it's very rare not to have a durable power of attorney, because you really want, that's the reason to sign them in the first place. The next is springing versus immediate, and this is where most powers of attorney are immediate powers of attorney. So let me just describe the difference. So an immediate power of attorney says the day Sam signs it, his mother, Joan, has the ability to manage his financial affairs immediately. Well, if Sam doesn't want that to be the case, if Sam, like the client I just described, says, I'm fine now, if anything ever happens, I want you to be able to manage my affairs, that immediate power of attorney is going to be tucked in a safe place until it's necessary for that agent to act. But when the agent has to act, their power went into effect immediately. So if they're dealing with the school or the financial aid office or a bank, they have authority day one. There's no further inquiry. And when the financial institution deals with that agent, that financial institution is dealing with Sam, period. The agent is a fiduciary, acting in good faith for him, but still Sam when in the presence of the organization. A springing power of attorney is different. And all healthcare powers of attorney are springing powers of attorney. So a springing power of attorney says, when you sign it, this power of attorney goes into effect if I lose capacity. Well, a financial power of attorney that's a springing power of attorney can be out in the field. Because before the agent can act and do anything for Sam, the agent's going to have to bring along proof that Sam has lost capacity and prove it to the financial institution. Because there's a precondition built right into the power of attorney. So when it comes to sort of, I've had maybe 5 or 6 clients in the past 15 years now who've done springing powers of attorney. And these are folks who hold everything really close to the vest. And they want to have all possible protections before an agent might sneak into the house and grab a power of attorney and go out and open a credit card in their name. But usually people are naming people they trust, right? The principle is choosing agents they trust. They choose successor agents because powers of attorney like guardianship, and guardianships can be temporary, but most guardianships, if there's a need, are for the life of the individual. And a power of attorney, if it's durable, is going to last for the life of the individual. And these documents can be updated because everyone's lives change. Sometimes I feel like in 5-year increments, there's always sort of a leap and things happen. And so folks create powers of attorney, but it's a snapshot in time as to who they want for their agents. But I always say stack the deck because life's uncertain. Yep.
When you sign the power of attorney initially, do you have to identify springing versus immediate, or is it more of a status?
You'd have to build in the condition making it springing. So the document would say, I, Judith, appoint Nancy as my primary agent to manage all financial matters for me on the condition that I've lost capacity to make those decisions. It has to be built right into it. Under our current New Hampshire law, our power of attorney statute was updated in the last year, and all powers of attorney are immediate and durable unless you expressly say something different. So the original agency law didn't have a concept of durability. It presumed that the person who was giving authority to an agent was always going to instruct them on what they had to do, and then the agent would do it, just sort of like a helper. But now we have the concept that in advance you can say, I might lose capacity, and I want someone to manage things for me. Yeah.
But you mentioned that all medical POAs are springing.
They are. So we're not going to skip ahead with slides. We'll get there, but let me describe it. So while you have capacity to make your own medical decisions, you run the show. And only in the event of a medical professional determining that you don't have the capacity to understand the healthcare choice being presented to you, noting it in the chart, or providing an opinion letter to your care providers, the individual runs the show. So all healthcare powers of attorney are springing, which is why there's a surrogacy law and why folks are thinking about supported decision making in the state of New Hampshire. Because and this, I'm going to take a deeper dive, but thank you for the question. This is a great question. So, so let's say you have a financial power of attorney. You can make that immediate. You don't have to lose capacity for someone to help you talk to the schools, manage your rent payment. You can get that out in the field. Healthcare, you have to be incapacitated before someone can make medical decisions for you, period. And so there's a hole in between those two because someone may need supports in a doctor's office, may need supports in communicating what their wishes are for medical treatment, but they have capacity. They're the ones making the decision. And so, you know, we have parents and a client who, you know, very significant physical constraints and ability to communicate, but he's absolutely competent and is making the decisions, except his parents can't go in and just communicate that. So supported decision making is something that New Hampshire and the Disability Rights Center and is building a coalition around to talk about how do we deal with springing powers of attorney and the limitations it puts on healthcare decisions. We want some supported decision making, but the person who still runs the show is the individual, not the people that are supporting the individual. So that makes sense. So healthcares are all springing, but financial can be immediate. Okay. I'm going to jump ahead a little bit. So I want to talk about limited powers of attorney for education decisions, because we've been doing more and more of these. So, you know, this is a POA that can be incredibly focused. And a POA doesn't just have to be about educational decisions, but this is the one that I've really been doing for folks who are heading off to college. And so it's a limited power of attorney, specific rights of an agent to handle detailed issues that the agent says, I'm willing to give the agent the ability to take care of these specific items for me. And you know, when I did this list, it really is about, you could do it over 18 if they're not going to college, but over 18 is capable of having signed an immediate financial power of attorney, but if the child doesn't want the parent running the bank account because they're able to do it and they're building certain financial muscles, then that immediate power of attorney stays in the back pocket. But they still want the parents able to sort of talk to the counselors and the educational professionals and to go to the IEP meetings and any other meeting about what that child's needs are, even if the child can't be in attendance. And that's the beauty of it. It allows for the sharing of information between the schools and the parent without that child saying, parent, you have all rights to manage any financial issue or educational issue. It's far more focused. And it allows the parent to stay an advocate for someone who's over the age of 18 who might be in school. And, you know, filling out financial aid applications, I mean, they're not easy. And so if you want someone else to have the authority to process it and then to pick up the phone and talk to the folks at Granite State to process the loan, it's nice for a child, Sam, as a principal to say, I trust my parents to just do these discrete tasks for me because I really don't need help with everything else right now.
Sam, can you go back?
Yep. Educational power.
This one?
Yep. Yep.
Wait,
Oh, no.
No, educational.
I
Yep.
have these.
Yep.
I was just going to say, my daughter just started going to the tech, and they have, granted this gives probably a little bit more, but they have releases too for the parents, where one is only financial and one is kind of all the other stuff. And
Yep.
what you were saying about kids asking certain questions, it's funny to hear the questions that she was asking about which ones, about each one and what I would have access to.
Right.
I was gonna say,
Right.
I told her if I'm paying your tuition, you're at least signing the financial one.
Yeah, the release,
Yep.
isn't it kind of,
A release is not, you know, a release is not the same. So,
No, I understand
yeah,
it's
yeah.
not the same. This does
That's
give
okay.
more, but it was
Yeah.
interesting because I didn't even think that they would have, but obviously they have to. You
Yeah.
know?
Yeah.
And like, she's like, I don't want you talking to this. So we didn't do the other one. I don't want you talking to my teachers. Not that I'm going to, but whatever. I don't care. But if I'm paying the tuition, you're signing off on the financial piece.
Right. You want to be able to
because
sort
if
of,
we have a release, we can, as a case manager, we could do these things.
but you're not able to make decisions about it. So it's like a HIPAA release and a healthcare power of attorney. So a HIPAA release, and I have another slide on that later, but a HIPAA release is just the ability to exchange information with a medical professional. You know, the person who signs it says, yes, you can receive my private medical information, but not make decisions for me. And so that's the difference between a release and a healthcare power of attorney. A healthcare power of attorney says if someone loses capacity, They make the decisions. It no longer is the person who lacks capacity that makes the decision. So I think when, you know, you could have a release, but the release doesn't give legal authority to make a decision, right? So if your child decided, okay, financial aid, but you know what, I'm going to bump it up to, well, you're going to have to co-sign anyway, so that's a bad example. But I'm going to get rid of it. I don't want to have debt, I'm going to get rid of it, without really being able to process the fact that without it, you can't attend the TAC. You know, the decision, even if you have a release, is the child's, not yours. And so that's the distinction between the release and the financial power of attorney. That's a great question. So I wanted to move on to healthcare powers of attorney. No, you're okay. Any other questions on sort of financial? I mean, the durability of them is really important. And, you know, having them go into effect immediately, but keeping them under lock and key allows for someone to be able to access it in a moment of crisis, perhaps, when it's needed. You know, the springing power of attorney, all healthcare powers of attorney are springing, as I mentioned. Yeah.
So a financial power of attorney would be like one step up from a rep payee.
So the rep payee is a limited, I think of it like a limited agency power. It's you serve as the fiduciary just for the one benefit, that's it. And so, you know, you could sign a limited power of attorney to manage, you know, the rep payee money, but it's just easier to do the Social Security Administration rep payee, and then you report on an annual basis to the Social Security Administration. But yeah, I think of it like a limited power of attorney to sell a house, a limited power of attorney just to manage that one cash assistance program. Yeah. Yeah.
Would it be helpful in trying to differentiate between an immediate and a springing to say, give an example of the language? Like, I hereby give you authority to manage my affairs with respect to my bank or whatever. Say I'm going out of the country. It goes into effect immediately. But would it help so that people could better understand what a springing, what the language sounds like that causes it to spring into? Yeah. So the springing power of attorney will say, as a, you know, I'm going to name an agent to manage my financial affairs, provided, however, that Nancy will not have authority to act on my behalf unless I've been determined to be incapacitated. And so that condition of incapacity is built directly into the power of attorney. And so if Nancy wanted to go out and use it, she's going to need evidence of incapacity. And so evidence for a financial institution may very well be a letter from her primary care physician that states she has a traumatic brain injury and is unable to manage financial matters anymore, and her powers of attorney should be activated. So I've seen that as sort of a piece of evidence that an agent brings to trigger the authority. And so the immediate power of attorney is silent. It simply says, I name Nancy to manage my financial matters immediately. No precondition of incapacity. She has that authority. And now, under New Hampshire law, a copy is as sufficient as an original. So, you know, we do so much electronically now that having an original in hand of a power of attorney is not as critical as it used to be. It's still critical for transferring real estate because the registries still require an original POA if someone's going to sign a deed transferring the principal's property to another, and the principal can't do it, so the agent's going to sign. An original is needed. But now you actually have to say in the document, a copy is not acceptable. It has to be an original. It's rare in my experience to do that because so much is done electronically now in emailing over a power of attorney and then contacting a financial institution to talk about a retirement account or to talk and say, I'm the authorized legal representative for an ABLE account because you can use a POA to designate who you want to serve as your authorized legal representative, let's say for one of those Achieving a Better Life Experience accounts. Is a POA embedded inside a guardianship document? And the second question would be that ruling that says that a copy is
okay. Is that nationwide or is that just for New Hampshire?
So New Hampshire adopt the Uniform Power of Attorney Act with some tweaks that are uniquely New Hampshire. The copy is sufficient is part of that uniform state national-wide laws. So there's uniform law commissions, and states that want to buy into them say, I'm going to take your template and then we're going to tweak the law and then we're going to end up with the state-specific one. So, you know, I have a lot of clients where I used to say you could provide a copy of a power of attorney, but I no longer say that. Unless someone needs to be acting on your behalf, they really shouldn't have a copy or an original. Yep.
With the copy now being as good as the original, does the original still need to be notarized to be effective?
It does. Yeah, it does. And so, you know, in years past, we used to have the seals, right? And then everybody was scraping over the seals with pencils so people could see them when a copy was made, you know, and then they went to just an ink seal, and now, you know, it does still need to be notarized in order to be a verified power of attorney. And a verified power of attorney has meaning to financial institutions because they can rely on it under certain circumstances and have a safe harbor if the agent is doing something they shouldn't. So having it notarized, you know, bleeds into having some certain rights under the power of attorney statute. I'm going to get to your guardianship question in a second.
I was just going to ask, if we have somebody that's coming out of a nursing home that's going to go into a staffed residence, and he's been his own guardian, and a lot of the people that have worked with him don't feel he can make the medical decisions, but other than that. So we had contacted for a public guardian, and the state didn't really feel like he needed one if the sister's willing to be a DPOA, which he had been at the nursing home. So we're just trying to figure that out, but I just wonder that when you say springing, because for him they feel like he needs help with every decision. So is that a DPOA is still just as good in that situation, or should it be a guardianship?
So it depends on whether or not the folks who have him in the housing, right, in his new residence, are willing to continue to take instruction from him, or whether or not they feel that they need to be looking to someone else, involving him in the decisions, but looking for someone else to make an informed decision on his behalf. And so, you know, that's an extremely tough situation, because powers of attorney are a less restrictive alternative than guardianship. And if he's able to sort of designate and understand who he'd like to serve as his agent, if he has legal capacity to sign it, that's great. He sounds like that perfect candidate for supported decision making, where he has the capacity to participate, but can he make the informed judgment? Are his functional limitations so severe that he can't process choices, assimilate all the information, and then communicate his wishes? Those are what an informed judgment is. And if someone doesn't have the ability to do that, then their capacity legally is impaired. And so it's just the springing power of attorney.
Situation, should it be a guardianship versus a DPOA, or is the DPOA sufficient?
Does he have capacity or not is the question. If he has capacity, he's making decisions. And if he doesn't, his agent can make them. So he could have a power of attorney put in place. If he has the capacity to make decisions about who he wants to speak for him, make medical decisions about his person, where he lives, what type of treatment he has, who his care providers might be, you know, if he trusts someone to make those decisions for him, he can name them, but it comes down to who are folks looking to make the choice. And it's really hard to answer the question, is a guardianship or a healthcare power going to do it? Because who are they going to listen to if there's a difference of opinion, right?
They're going to probably listen to the POA, so does that make it okay?
If they're going to listen to the POA?
Right, they feel like the sister should be making medical decisions.
So I think when it comes to the provider or the residence that he's at, they're doing their own risk management as to the safety of the person who's with them, right? And so if they take decisions from an agent and he says, you should never have done that, I have capacity, you shouldn't have done it, then that, you know, guardianship gives a great deal of cover, right? And so there's safety in some respects when third parties are dealing with a guardian, because that arrangement is a legal arrangement that the court says you are the guardian over this person's person, right? And you have the authority to speak today. The court's made that incapacity determination. Someone else has to make an incapacity determination before someone can make decisions as an agent under a power of attorney. So it's sort of difficult to answer the question. And I guess I come back to, if he was my client and I thought he had the capacity to sign a healthcare power of attorney, you know, we could limit it so that, you know, all participation, it has to be with him and decisions have to be made together. But someone has to trigger it. Someone has to say he can't understand medical decisions anymore. At some point, someone has to look to an agent or to him for medical matters. That's why the supported decision making, I just feel, is so critical in New Hampshire. If we can get that off the ground, you're going to have people who can speak for him, but he could fire them because he has the capacity to participate in the process. There's sort of a hole right now when it comes to, you know, medical decision making. I don't know if that was helpful.
Well, it's a tricky.
Yeah, it is a very, yeah, it's a tough one. You have a question, and then, I'm sorry, and you have one too. Go ahead.
Yes, and so for the to be appointed a guardian,
yeah,
you have to already or previously have been determined to be incapacitated.
In order to have a guardian appointed, it is a legal process to determine your lack of capacity to make decision.
It's not, we think, but
not at all.
Power of attorney, that legal, the evaluations that are involved and whatnot, that's not the requirement there.
So with a power of attorney, it's private, so you're outside of the court process. So if someone has named an agent, and an agent has the power of attorney in hand, and the agent wants to start making medical decisions for someone, it's going to be rare for a doctor or a medical professional to work with an agent unless that doctor or medical professional is confident that the individual lacks capacity. So the springing power of attorney has some protections in it, right? There has to be that precondition met. You have to have lost capacity in order for your agent to make decisions for you. But in the immediate power of attorney for finances, it's a little grayer, I hate to say, because it could be a letter from a doctor saying, activate the power of attorney because this person can't manage money matters. That might be enough for an agent to have in hand and a financial institution to rely on.
But to officially enter into a guardianship, you have to have that condition.
You have to prove it in court.
Right. And to enter into a POA, you do not. It's more, it's the upon is happening.
That's right.
Okay.
Yep. You have to have legal capacity to sign a power of attorney. You have to understand the power of attorney before you sign it, and you're saying in advance, if I lose capacity, I choose these folks to step in and help me. Yeah.
I'd like to answer more questions at the end if possible, if you can just jot them down on paper, because we're recording this for the website afterwards, and we have a limited amount of time. Unless you have something that's urgent, if you can hold it, that would be awesome.
Okay. Right. So we talked a little bit about HIPAA releases already. Again, that's just the goal to allow a free flow of personally protected medical information between the patient and a third party that they name, who can have access to it. But a HIPAA release does not authorize an individual to make a medical decision for the patient, okay? Difference between a release for finances and the agent acting under a power of attorney for finances. I do want to talk about surrogacy for healthcare because I sort of describe it as a stopgap measure, but it's not a replacement for doing powers of attorney if someone is able to sign a power of attorney in advance. So New Hampshire has a surrogacy law now. Massachusetts and some sister states have had them for a long time. So if someone never signs a power of attorney for health care, and never appoints an agent and happens to lose capacity, there's a law on the books that says an order of priority, individuals in an order of priority can make medical decisions for the patient, but only for a period of 90 days. So it's a stopgap measure. It's for sort of emergency medical decision making when someone can't rush into court and get an immediate guardianship, and because someone didn't have either the forethought to sign an advance directive. And so, you know, I've had some folks come in and say, there's a surrogacy law, I don't need to worry about it. And I said, well, you know, you've got 90 days and that's it. And after that 90 days, if you still need help, it's a court process. Secondly, if you rely on surrogacy, you as an individual lose the ability to define who's going to step in, because the state law says who's going to step in, what's the order of priority, who's making decisions for you. And so having the power to sign a power of attorney, well, that's a little alliteration and repetition, but you know, it gives you the ability to define the scope of their authority for medical matters and to name the people that you want, and it's durable. It's going to last for the rest of your life if need be. So relying on surrogacy, it's a wonderful, wonderful statute to have in New Hampshire for folks who don't do planning. But it's not a solution or a substitute for a healthcare power of attorney. So I want to talk a little bit about, and I think this ties into one of the questions that I had about capacity to sign a power of attorney. So, you know, it depends on whether or not the individual has the power, you know, the capacity to sign a power of attorney. I spend a lot of time with clients when I'm concerned there might be some impairment, because I really need them to understand that these are powerful documents. You're cloaking individuals with a lot of authority to make decisions about your person, your financial and medical well-being. And so the things that I ask about when I'm sitting down with clients is, do they understand what an agent is? It's one thing to say, sure, it's an agent, it's someone that I name, but what's the role? What are you actually allowing this agent to do for you? Everything that you could do if you could understand it. And so having the scope of the POA defined is really important, and this is where I walk through the questions with, you know, younger individuals who say, what am I giving a parent the ability to do and what am I not giving them the ability to do, and when do they have that authority and how long will it last and can I change it? You know, that's always the critical one. Well, what if I decide to name a best friend, or what if I decide to get married? And you know, these are evolving documents. They're living, breathing documents that will change. And as I said, that general power of attorney for financial matters, it's incredibly powerful. If an individual has it and is able to manage money matters, it's every money matter. It's contractual, it's selling property, it's taking out a loan. So just talking with sort of Sam about whether or not Sam wants to limit the scope, and knowing that Sam can terminate the agency relationship as long as he has the ability to understand what's going on. Just because you name someone doesn't mean they're always going to serve. It also, from an agent perspective, it's not indentured servitude. Just because you're named as an agent doesn't mean you have to step up and serve in that role. And so, you know, I met with a client just 3 days ago, last week, and it's a sibling, and she doesn't want to manage her sibling's finances anymore. And there's a successor, thank goodness, who's willing to step up. So there's no hole, there's no need for a guardianship if she just simply declines to serve. And so an agency relationship, it's a contractual relationship, but it's not mandatory if you're naming an agent. If they don't want to serve, and life's uncertain, someone might not be able to take on that job. So again, I just want to sort of talk about, because I want to start moving from powers of attorney over to guardianship, that no one can sign a power of attorney until they're 18, because they don't have the legal ability to sign a document like this until they're an adult and cloaked with all of the legal authority of an 18-year-old. And so determining capacity to sign a power of attorney, well, I'm asking the questions like, who would you like to name as your agent to make medical matters, medical decisions for you? And do you want to put any limits on what they can and they can't do? And it's walking through those types of questions. And it's really hard to have families come in with, say an 84-year-old or someone who's turning 18 and say, I don't think this individual has the capacity, the legal understanding of what this document is. And that, you know, you have to go for guardianship. But I always prefer to sort of start here, because this is private and outside the court oversight, and it gives the individual the power to choose the people they want, and it gives them the ability to select what authority an agent is going to be able to exercise for them. And so this maximizes independence. And so I always want to start on the side of the power of attorney versus immediately going down a guardianship route. If we ultimately can't sign powers of attorney, guardianship's going to be necessary if someone doesn't have the capacity to manage money matters or healthcare decisions. And only a court is going to be able to determine that someone needs a guardian, right? So I might be able to say, I'm not comfortable having this individual sign a power of attorney. And I have asked for medical information so I can analyze it. I've met with individuals more than once in order to just really see if I can get them to a place where they can understand the power of attorney document itself. Not every decision an agent has to make, but what is the document? What are they giving someone the ability to do? And tease out whether or not they understand it or not. But if Sam can't or won't sign powers of attorney to handle finances or make medical decisions, and if he's vulnerable, if he's super generous, if he's going to open the door to a stranger, if he's going to get into a car or go into someone else's house, vulnerable to others, if he's mercurial, if his wishes change one moment to the next, and he might say, I'm fine, agent, handle things, and then give me that document back, I fire you. You know, so if he's not able to stay the course, if he's going to sign a POA and revoke it the next day, it's his right to do so. But if he needs a guardian, if his decisions are likely to place him or those around him at risk of harm, then some form of guardianship might be appropriate. And as I said, the courts are looking for the least restrictive alternative. So if someone can sign a POA, the courts would prefer this, rather than having someone under their oversight for the rest of that individual's natural life. And that's sort of what guardianship is going to be. So guardianship at its core is a legal relationship. It's a relationship defined between people by the court. And so the individual who's bringing the action to take over some legal rights of another individual is the guardian who's seeking permission, petitioning the court for those legal rights to be shifted over to them. And the ward, the proposed ward, is the individual who needs protection, who needs someone to be able to make decisions for him. And because that ward is deemed by the court to lack sufficient capacity to manage his or her own financial matters or property, and make and communicate important life decisions, including about medical care, it's actually an adversarial process. You know, it is someone coming in and saying, you are an adult, you have legal rights, and I'm going to sue you to get those rights taken away from you and given to me, because there's a need to do so. In court, I want you to understand that need, and I want you to give me the ability to make these types of decisions. And so it should be harder to get a guardianship. I mean, situations are different. Some guardianships are very complicated. Some individuals might fight a guardianship, and some are seamless, where the individual knows they need supports and trusts the people who are bringing the guardianship action. So when it comes to guardianship and incapacity, the court has to be looking at a legal disability of someone. It's not a medical disability by a doctor. It's a court-determined legal disability, and it's based on functional limitations of the proposed ward of the individual. And this means that that proposed ward either already suffered, is suffering now, or in the future is likely to be at risk of suffering some type of substantial harm due to that inability to be able to manage personal needs like health care and housing and shelter and food, medical decisions and privacy, or an inability to manage money, property, and assets the individual might have. And, you know, functional limitations, my grocery cart, because, you know, the court is really looking not just for an isolated incident, they're looking for specific behavior or conditions that this individual might have that's going to impair their ability to perform activities of daily living that some of us may take for granted every single day. And those activities of daily living are needed to secure and maintain a proper food, clothing, shelter, the laundry list of things that ensure the individual is safe, or that those around the individual are safe.
I just want to mention, I had a gentleman once who had ALS.
Yeah.
He could not perform any of those activities on his own, but he had capacity, and he arranged for other people to do it for him.
Yeah.
And so he was not considered to need a guardian.
Yeah.
So even though he was not able to perform those activities for himself,
he was able to direct
he was able to provide for them.
Right.
So.
Right. It is. It is. And did he have a power of attorney in the event he ever wasn't able to do so in the future?
He ended up passing away before POAs.
Oh, okay.
So.
Okay. Yeah. All right. Go ahead.
With the ABD waiver and the DD waiver, would you ever expect to see someone with a level of disability of an institutional need not have one or the other in place?
Would I expect to see it?
Would you ever think that you would see that in place, that they have an institutional level of need and not have one of those safety nets in place?
So I have seen it, and I've seen it because families have built a bubble around an individual so that when, you know, that even, so I'm going to talk about filing for guardianship. It requires you to provide instances of not a pattern of behavior, but 6 months prior, instances that are showing that these functional limitations exist, and they have placed this individual at harm and risk of harm to themselves or others, and some in the last 20 days. And sometimes it's really hard for families to find those because this individual has been so well supported, which is what families do, no harm could possibly come to them. And so there's some tried and true things that we talk through when folks are faced with that, but I actually have seen folks get all the way through to age in their early 60s, and an 82-year-old mother passes away, and this individual has never been connected to the system at all, and they've never been under guardianship, and they don't have any powers of attorney, and they're not able to. So yeah, I see it, unfortunately.
Yep, we do too.
Yeah, yeah. And I think when it comes to medical matters, you've got this 90-day window if there's a crisis, but guardianship, you know, it's harder to prove when you don't have those occurrences. Yeah, that's a great question. So when they're looking at proof of functional limitations, yeah, so they're looking at an inability for that individual to provide for their personal needs. So in your circumstance, they were able to provide for their personal needs, not personally, but they were able to delegate and request that those personal needs be provided for. But if you have an inability to even do that processing, to make the connections that you can bring in help, and you can't do it yourself, and if you don't have the ability to provide for your personal needs or to manage your own property, that has to be proven in court, as I said, by those specific occurrences. And so when an individual, these aren't isolated incidents, when an individual applies for guardianship on behalf of another, because at age 18, they are an adult and they have the full panoply of legal rights. And so a guardianship is going in and saying, some of these I need to shift over to me in order to keep this individual safe because they have functional limitations. And as part of the petition for filing for guardianship, those occurrences have to be recent. They can't be, you know, 7 years ago. In the last 6 months, there have to be occurrences, and at least one in the last 20 days. Part of the petition. And it's not part of the slides, so don't shift ahead. So, you know, some of the things that we just mentioned, and it's interesting that you asked that question because, you know, sometimes parents are taking such great care of an individual that they're never going to have fallen through the cracks, or you're never going to see an incident. And so some tried and true things that are part of guardianship petitions are, you know, what if an individual can't remember to take medication daily? They just simply can't remember to do it, and it's absolutely critical. What if they can't make change, but they understand the concept of money? You know, what if they can go to the doctor's appointment and they can present well, but they're not going to be able to assimilate and differentiate between the different options available to them without a parent present and in the room. You know, I had a client who we were trying to tease things out, and she said, you know what, someone came knocking on the door, I was in the back, and my child just opened the door to a perfect stranger, after having been told and advised how dangerous that is. Those are some tried and true things if there's not like a critical drop in someone's safety. And so part of that. Yeah, of course.
So
I'm just going to go ahead.
17 and a half years of age, you'd want to start documenting like dates and times of
No, you're good.
occurrences, or does it have to be a police report, or does it have to be like a teacher or somebody documenting for you, or what would you recommend as a good
So it's a great question, yeah. So, you know, when I'm thinking about timing and filing for guardianship, depending upon what circuit, jurisdiction of the probate courts you're in, some probate courts are going to allow people to maybe file the document 4 months or so before age 18, and some courts want it only when they turn 18. But doing advanced planning is great. There doesn't need to be a police report about safety concerns. You know, no one knows your child better than you know your child and what your child's needs are. And if you're evaluating and you've, you know, come to the conclusion with your child's participation or not, depending upon, you know, whether he or she can, that a POA is not available, then thinking about what those functional limitations are. Where do you come in and really make up the decision making for that child, and just start jotting it down. You know, otherwise when you're filling out the petition, then you're going to have to think back, and in the moment it's so much easier to write it down in the moment than try to recreate an event or an occurrence later on. Yeah. And so at the tail end of these slides I have, you know, some information that you might want to be thinking about collecting if guardianship might be needed. We're putting together on our website a letter of intent. It's going to be a fillable, you know, form that you can just print out, but it walks people through, you know, how does a family member tell someone else who's going to step in later everything they know about their child? You know, because nobody knows that child better than the family. And if you have a guardian or an agent under a power of attorney, isn't it important to understand all of these nuances about their care and their needs? So I mentioned that there has to be a pattern or a history of functional limitations, and that these can't be isolated incidents. You know, the lack of an ability to save or to set aside money, or the fact that someone's overly generous when they get the money, or, you know, just because someone makes a misinformed decision, a bad judgment call, you know, that's not enough to say guardianship is necessary. As an adult, we are entitled to make bad decisions, you know, and so, you know, it's just not sufficient to just say someone lacks the ability to provide for his or her personal needs or to manage property. You know, it's about whether or not this person can make an informed judgment. Can they really walk through the process of what it means to make an informed judgment about this particular medical treatment or that particular medical treatment, or whether or not to take out a loan or not, or whether or not to apply for SSI benefits or not, or Medicaid assistance benefits or not. You know, it's about informed judgments. So informed judgments there's a legal definition for it. You know, so just so we're boxing people in, it's not something that's a little more fluid in a POA scenario, right? Whether someone has lost capacity, can a financial institution rely on a letter from a doctor? The court is going to be much more meticulous. They're looking about whether or not that individual, that proposed ward, the person that you're trying to take the rights away and give it to another person, has the ability to voluntarily, after going through and receiving all relevant information necessary to make a decision, who understands that they're free to reject a particular alternative or accept a particular alternative, can clearly express their choice. Show an intention about that choice. And this entails quite a lot of executive functioning skills. You know, it's about being able to evaluate alternatives, assimilate information that's being given to you, and then articulate what your wishes are. And so that's what the court is looking for. Does this individual have functional limitations that impair the ability to make an informed judgment about their health care decisions or about the management of property? So if someone actually does need that level of assistance in making decisions about health care and financial matters, if they can't exercise an informed judgment, and they can't sign powers of attorney as a less restrictive alternative to guardianship, then that guardianship likely is going to be necessary for someone over the age of 18. That's going to entail filing a lawsuit in the probate court. And this is, you know, it's potentially an adversarial proceeding because it's one person suing another to shift over legal rights. And the proposed ward, like Sam, is going to have a lawyer appointed for him. And the court has a list of lawyers who have agreed to serve as an attorney for a ward. And when parents are filing or an individual is filing a petition for guardianship, they're going to need, as I said, to list occurrences about functional limitations in the last 6 months and at least one in the last 20 days. And so that might entail providing medical records or you know, an educational plan. It might require testimony, medical testimony of a doctor. Let's say a ward decides they don't want a guardian at age 18. It's entirely their right. They have legal rights at age 18. They want to hold on to them. And so, you know, I'm going to jump ahead. There's a couple of things that I didn't put on the slides. But so when a lawyer is appointed for a guardian, for a ward, a proposed ward, the job of that lawyer is not to figure out what's in that ward, proposed ward's best interests. That's not that lawyer's job. The lawyer's job is to advocate and limit and narrow the guardianship if that's what the proposed ward wants. And they're going to try to tease out from the proposed ward in a meeting what that individual, what Sam wants, what he's willing to do. And if Sam puts up a wall and says, absolutely not, I want to fight this tooth and nail, then the job of the lawyer is to fight it tooth and nail. Because it really is an adversarial process. It doesn't end up being that way in many, many guardianship proceedings. Because when you talk to families and the lawyer's talking to the ward and they're trying to figure it out, you know, the individual has been relying on, say, the parents for so long that they just want to continue having them at the table and having them continue in the roles that they've been in. So it's not that common to have a contested guardianship proceeding. And really about 70% of my clients don't want or need a lawyer participating in the guardianship proceeding, especially if it's just guardianship over the person, because the individual doesn't have property, doesn't have an estate, and there's a representative payee that can be done to handle just a Social Security check. So there's no need for a guardianship over the estate. And so if someone's going in just for a guardianship over the person, the ability to figure out where this person's going to live and whether or not to stay in school until 21 and what treatments are needed with doctors and what care providers need to come into the home, I have a lot of folks who come in for a one-time visit. Just map it out for me, Judith. Tell me what has to be done. Show me the petition. Let me know, what's going to happen after I file it. And so, as I said, they're going to file. The court's going to appoint an attorney. There's going to be a hearing date set. And the person bringing the guardianship is going to have to stand up in court and say, why is a guardian needed? And discuss those functional limitations. Does the child have to go to the hearing or not? Well, the child doesn't have to if a medical professional says, he or she won't understand it, or it might be traumatic for him or her to be there. But judges like, in my experience, to see the child. I had one ward who grabbed the microphone and she was just so happy to talk to the judge, and it was wonderful. She was fabulous. And the judges want to understand the individual. And when it comes to sort of the petition and looking at sort of what should we be putting into the petition, you know, the petition, I brought a copy of it, but you can go to the probate court website if you need, if POAs are off the table. You know, there's frequently asked questions at the probate court website, which are really helpful to parents that are looking to fill out a petition for guardianship. You know, there's going to be a legal presumption that the guardian, that the ward actually has capacity. And can you go back one? I just think that I'm jumped ahead. There. Oh, nope, one more. Yeah. There's a legal presumption that the ward has capacity. Age 18, we're magically endowed with all the legal rights of an adult. And so, you know, courts are really, really cautious about taking away the legal rights of an adult. They want that level of proof that it's absolutely necessary to do so. And the burden of proof is on the person who's seeking the guardianship. So if a parent comes in for a child and said there's functional limitations that impair, you know, Sam's ability to make informed judgments about his medical care, they're going to want to ask questions of the parent. Why is that? Explain it to me. I mean, the judges are going to take the cue. Some guardianship proceedings are back in the offices of the judge. Some are in open court. Some are long. Some are short. But the burden of proof is beyond a reasonable doubt that a guardian is necessary. It's a criminal level of proof. It's not just, oh, you know, a little bit more than less, 51% needs a guardian. No, it's beyond a reasonable doubt, because the court doesn't want to be taking away legal rights of an individual unless it's absolutely necessary. And now we're jumping. So there are two different types, and I've mentioned them, of guardianships, just like there's two different types, general types of powers of attorney. Powers of attorney for finances is the equivalent of a guardianship over the estate. Powers of attorney for healthcare and medical matters is the equivalent of guardianship over the person. You might not need, as I mentioned, both a guardianship over the person and the estate. If the individual, the proposed ward, doesn't have assets, and all they're going to receive is an income stream, and if that income stream from Social Security can be managed by a rep payee, then the courts really don't want to have a guardianship over the estate. They'll just limit it to a guardianship over the person. So, as I mentioned a little bit already, Sam has rights through the guardianship process. And, yep, go ahead.
Sorry,
no.
Is it better, since you're going through all this whole process, if your person is more not able to make decisions at all about anything, or much lower functioning level, to try to do both at once?
So the courts want guardianships to be as least restrictive as possible. So in my experience, they're not going to give a guardianship over the estate if there's no estate.
Okay, so you have to have some property to be able to...
Yeah, you have to convince the court that it's necessary. Oh, so better planning is to tell the grandparents to leave it in a trust for the person, but yep.
That's
yep.
November.
Yeah.
Come back in
yeah.
November.
Yeah. So my experience is the courts are not going to want to open a guardianship that's not necessary in the moment.
Have they done it? Have you had anybody? I'm just sorry.
No, it's okay. So I have had one circumstance where they opened a guardianship over the estate before the ward actually had the money. And it was because it's the scenario that you just described. So because the grandparent had died, the assets were in a probate process that was not going to arrive and land with the child until, you know, a year from now, going through a probate process. And because we knew the money was coming and we wanted someone to be able to manage it, it was a fixed amount that was going to be coming to the child, so it was a known inheritance already. That would be a circumstance. But it's really hard to convince the courts that they should delegate resources and receive a report from a guardian over the estate that says nothing has happened because the ward has no money every year, and they have to keep a file open, and they have to, you know, receive these accountings that say nothing, right?
Send it to the individual and both guardians.
Yeah, yeah. You're welcome. Go ahead.
I had one come in, and it came in as a conservatorship over the estate only.
So a conservatorship is sort of an interesting It's sort of in between here. So if an individual is, conservatorship is a voluntary process. So someone says, you know what, I want court oversight, but I want to choose the person that's going to be my conservator. And I want to make sure that I hold their feet to the fire because I trust them, but I don't trust them 100% like I would with a POA. So I want a court to oversee my conservator. So it sort of falls in between those. It's not as common in New Hampshire. And so the question is, you know, it's always those people who hold it close to the vest, right? The ones who say, oh, I trust this person, but I do want some oversight, you know, and so that's a conservatorship, a voluntary kind of POA hauled into court with court oversight. That's sort of the metaphor I'd use for it, yeah. So I talked a little bit already about the fact that Sam has the ability to object to the guardianship. And there was a case that went up to the New Hampshire Supreme Court because there was an attorney appointed for a proposed ward who actually was advocating what was in the best interest of the ward, rather than being the advocate for Sam. And if Sam said no, the individual who was appointed in the case that went up to the New Hampshire Supreme Court was saying, well, it's kind of in your best interest, so I'm really not going to fight it. You know, that's not the lawyer's job. And so it's just knowing that going in, that Sam has the right to say whether or not he or she wants a guardianship and whether or not they're going to contest it. When evidence like a police report would come in, probably in a contested guardianship arena, right? That someone has been out driving and has kept their driver's license and is causing a risk of harm to themselves and others because they can't process the inputs in the moment that's required for a driver. That a police report could come in as evidence in a contested guardianship, but it's often not needed when it's not contested. So thinking about who might serve as guardian, you know, family members, parents, siblings, they often serve. Some things to consider when coming in as a guardian, and I mentioned it a little bit earlier. You know, I have a sibling and another sibling with a traumatic brain injury, and the sibling number one says, I want to stay a sibling. You know, I don't want to be in charge of purse strings. I don't want to be making medical decisions. You know, I want to be involved, but I don't want to have the authority to make that call. So it's really thinking about, do you want to proceed with a guardianship, and do you want to take on the role? Oftentimes a natural transition for a parent of someone who has needed help all the way up to age 18. Co-guardianship, as you mentioned, two guardians, co-guardianship is really nice for a couple of reasons. The first, it allows for sharing of responsibilities, and the second, it allows for a seamless transition if something happens to one of them, right? Because a guardianship is a court-defined legal relationship. And so if the guardian, there's only one guardian, if that guardian dies or becomes incapacitated or steps away, an entirely new petition for guardianship has to be filed to appoint a second individual. So if you can have co-guardianships, really nice for just continuity and no interruption in care. Okay.
So would you file a motion to add a co-guardian, or would it be a successor guardian? Or is it
you can't name a successor guardian the way you can name a successor agent under a private power of attorney.
Okay.
You can name co-guardian. It would be a motion to add a guardian.
Okay.
Yep.
So if you did if you did in your trust, could you name a successor guardian there? If, you know, if you put in another legal document that you would prefer this person, I'm the guardian now.
Yep. Yep.
I pass away and I want my child's aunt to be the successor.
The successor guardian, the one who brings the next petition and becomes.
Would the court listen to that as part of the guardianship proceedings?
That's a great question. So in New Hampshire, under a last will and testament, that's the document where you would express your preferences on who you would like to be the guardian of any of your minor children. I have included in last wills and testaments for anyone who's over the age of 18 but needs additional supports and might need a guardian. Courts are always going to look at preferences that are articulated by family members. So yes, but it doesn't mean that the court will appoint that person under every circumstance, because they are going to vet the person. There has to be a criminal records release. There's releases that have to be provided to the Department of Health and Human Services. For the potential guardian, the court is really vetting whether or not this is a proper person to be in that position. So even if you say, I want this person serving, if the court decides they're not fit for some reason, there's going to need to be a different person. But you can absolutely express your preferences, and courts give deference to it.
In a follow-up for that, sorry, if you add a co-guardian, you have a guardian in place already, and you add a co-guardian, would they have to sign that $10,000 bond too? So there's two $10,000 bonds, or is it one $10,000 bond?
It's going to stay with just one bond. Okay. And the bond, if there's a guardianship over the estate, the court wants to make sure that the guardian's not going to run off to Foxwoods and go through all the money, right? And so if the estate is over sort of $10,000, you would need to have probably a corporate surety bond. New Hampshire doesn't have sort of, I mean, it has some minimal ones under $10,000. You could just say, I honor the fact that I have, you're going to have some vetting about your ability to repay the 10 grand. But if the estate is not over the 10,000, the answer is they wouldn't. They're going to have the same personal recognizance bond.
I thought I had parents that I went to court with that didn't have the estate. They just had the person, but still had to sign a $10,000 bond. So, and it could be jurisdictional, okay, and it could be at the time. But I haven't had a co-guardian coming on board have to sign. Okay. Some judges will require it, and some judges will not. Okay. But I can take a look at that and get back to you, and you can let folks know. I haven't had it come across my desk. I have a release for a particular account I can look at.
Yep. And so when we open the guardianships over the estate, it's usually either temporary to deal with an inheritance so someone can figure out what to do with it, maybe put it in a self-settled special needs trust. So it's a temporary guardianship to do planning with the ward's money, or it's a long-term guardianship because they actually have assets. And if they have assets, the court typically is going to set the bond at the value of the assets. And $10,000 for a $100,000 estate is not going to cut it for the court. They're going to require a corporate surety bond by the guardian, maybe $200 a year to pay for it, but it ensures that if the guardian did something they shouldn't have with all that money, the ward's still protected. And that's what the bond's intended to do, protect the ward. Yep.
I have a question too.
Yeah, I'll check into that though, Nancy.
If you're going to have parents, say, husband and wife, and they want to maybe have kids, guardians, is that complicated? Say if the husband and wife, and then you wanted to add two of the individual siblings, so that it was a more smoothless transition eventually.
So I'd say once you get into 3 and 4, it becomes a committee, right? And it's harder to make decisions. 2 people, co-agents, co-guardians, 2 can kind of get together in a room and hammer it out. 3 is nice because you have a tiebreaker, but at some point I think it might be too many. And I think that you look at, the worry is that if you have parents, they're going to die in a common accident, right? And then there's going to have to be someone who steps up and says, I'm going to file a petition for guardian, I'm going to be the successor guardian. I think that if one passes away and the surviving parent says, now I'd like to bring someone on to serve in case something happens to me, that's how I usually see it. One goes off and another comes on to keep 2 guardians. It's when I've seen 3, it's because the family doesn't necessarily function as well as some other families function, right? And so they want that check and balance. I've also seen 3 when it's been blended families, where a child from one marriage and a child from another marriage want to step in and they're still a spouse, and so I've seen that. It doesn't work as, it's a little more clunky, I guess, is the point. But sometimes family members can't serve, don't want to serve. And so in that instance, we're looking at a public or a private guardian. We have Tri-County CAP in the state of New Hampshire. We have the Office of Public Guardian in the state of New Hampshire, and we have some private guardians in the state of New Hampshire. Whether or not they're going to be able to take on new wards and clients is another question. And so I think just systemically, over the last 10 years, I've seen a need for more third-party guardians in the state of New Hampshire, but it's a challenge because they have to report to the court and they have to earn a gainful wage, and the court evaluates how much of the ward's money they're spending, and so it's a delicate dance for a private guardian. How do they pay themselves to do a good job when family members are not going to be paying themselves to taking care of another family member? And so there are public guardians out there. I think interviewing them, really getting a sense of who the individuals are, is really helpful. Knowing what the team on the guardianship level will be if it's a public guardian, so that if you're not talking to one person who does rep payee money and another person who does medical decisions and another one who handles property, it's good for a parent, if they're not going to serve, to know who that team is. But if you decide to let a third party make decisions, the parent's wishes might be heard, but not necessarily followed, right? And so it's just, what do you want to do? Coming back to that beginning question, do you want to step in or not step in? So the powers that a guardian is going to have, just like, you know, under a power of attorney, the individual, the principal who signs it, gets to limit the powers. It can be very broad or it can be limited. The court is going to define the powers. And as I mentioned, the court is looking only to be the least restrictive scope. You know, guardianship they want the least restrictive alternative to narrow how many rights they're taking away from a proposed ward. And so when I have clients who come in and they've already filled out a petition for guardianship, which you can go to the court website. If it's necessary, you can download it. Guardianships are filed online, although the hearings are in person. You know, there's a laundry list of rights and powers that a guardian, proposed guardian, might want to sort of siphon off of a proposed ward. And my advice to parents is just be judicious. You know, don't go in and check every single one. Really think about what it is that you're asking to take away from the ward. I mean, just as a couple of examples. You know, do you want to control travel and deciding where someone lives? Do you want to control whether they can marry or divorce? Make a will? You know, I've had folks who are under guardianship but have been deemed to have capacity to figure out and articulate in an informed manner who they want to inherit their estate. And so, I mean, the right to control your own inheritance, I mean, that's a powerful right, and to just check a box, the court's going to ask why. What functional limitations lead to this person not being able to make an informed judgment about this particular box that you've checked, right? And so it's really about being careful and going through it. If you have someone who's incredibly generous and has a guardianship over an estate, you might want to check not able to make gifts and not able to sign a will. You know, and it's just looking at the individual to really decide what are the rights that you're looking to sort of exercise for them, and doing it judiciously, because the court's going to ask the question, why did you select this one over that one? So really that order is designed to maximize the liberty and the personal freedom of the ward, not just go in and wholesale take the rights away. So this is where we're moving off of sort of guardianship and POAs, and I'm happy to answer some questions on guardianships. I just have a little bit of information in here about if you're thinking ahead and you're looking at the fact that you know a child or a sibling or someone in your family who's in need of guardianship or may lose capacity later on, you're looking at how do you put together as a family to build a roadmap so that the transition, if you're gone, is as seamless as possible for this individual. And you know, working with Sam, in my example, is critical because Sam has wishes just like the parent has wishes. And so just writing down, as I said, sort of the family information and history. Because the person who steps in as a guardian afterward might not be a family member who has this information at the ready. They don't have the institutional knowledge of your family. They don't know all of the relationships that Sam has built over the course of his lifetime. They don't have the family medical history. You know, and so just thinking about how you can write things down, that's sort of part of what I talk to clients about, a letter of intent. And it's just really how can someone who knows this individual best describe, you know, what a daily routine is like for them? Is there a trigger that's bad versus language that usually brings someone around and back to the table and calm again? Is this someone who has a diagnosis, or have they had multiple hospitalizations for a particular reason? And if a person who steps in later in life as a guardian, after you're gone, doesn't know what the triggers are that have triggered a hospitalization or an admission somewhere, isn't it nice for the family to give them that roadmap in advance? Even if you keep it in your pocket or with your other estate planning documents, just sort of identifying it. Habits and routines. I couldn't find any better folks, but it looks like Sam. You know, so an individual might have a routine that if you just took out one of those activities, it's going to throw the entire day off. But someone coming in cold is never going to know that in the way that you know that. And then sort of, as I talked about, sort of just knowing some stress relieving techniques and things of that nature, and behavior do and don'ts in a household, or whether or not this individual needs to be living in a communal setting, or would he or she prefer to be a little bit more solitary, because, you know, inputs of light or physical touching might give a reaction to an individual, and you might have someone who absolutely wants to be in the middle of all the activity with all of those inputs coming in because it quiets the mind. Just thinking about if someone's able to work, what was their employment history? Were they in a supported work environment, and what made it work when they were there? You know, because at age 60 or 50 or 40, you know, what you know at 18 is going to be critical, because it's going to influence the development and the happiness of that individual later in life if the circumstances can be repeated later. So this is really just sort of thinking about what you can put down, pen to paper or in a computer, that downloads your knowledge of the individual so that the transition when you're gone is seamless. Yeah.
Could you have it sound like an Excel sheet where, like, you know, you could update it every 3 years after 18, just so that
yeah.
it would be like, okay, well this, like, you know what I mean, like something like that, like a checkbook almost, that you kind of
yeah.
can keep updating it every few years, so like, in case something happens to you, then the next person would know.
Yep.
The history a little bit easier.
I think it's a great idea. What I'm going to have on the website, and I don't think it's up yet, we've been working on that very thing, and it has different pages that can be updated, downloaded, and it prompts with some questions to think about so that you can just start filling it in. You could download it to your computer and update it when you want. We've called it a letter of intent, which is, this is how I intend this, you know, the person that I love to have the maximum independence and the best quality of life later on. I've made it happen with these supports, and I want to make sure that you know how I did it. Yeah. So, you know, we're going to be talking a bit about sort of government benefits and maximizing government benefits through the use of estate planning documents, through achieving a better life experience accounts and special needs trusts, and how do people plan for an inheritance so it doesn't go directly to someone who can't manage it, forcing a guardianship to be opened in court to ask for permission to do planning. And so that's sort of going to be our October presentation rather than our October and November actually together. So I just had that slide up there as a teaser for the next round.
I appreciate that.
Yeah.
Thank you very much for that.
Oh, yeah.